Our jury's out of the courtroom. The other issue with regard to Mr. King, Mr. Bankowitz filed motion to discharge on November 21st, alleging that the trial had not commenced within the speedy trial period. However, this jury was in fact selected and sworn within the speedy trial period, at least within the recapture period of the notice of expiration. Florida law, in my opinion, is fairly clear. The Supreme Court has repeatedly said that a trial commences under the speedy trial rule when an initial oath is administered to a venari for an individual trial. This jury was actually selected and sworn for the trial within that time period, so the motion to discharge is going to be denied. Now, what are your issues?
Your Honor, last week at the pretrial conference, both Mr. Barrow and Mr. Smith executed stipulations to the identification of Demetria Robinson as the deceased. Mr. Bankowitz and Mr. King were not present. They have executed that this morning. May I approach?
Yes, sir.
Also, Your Honor, I have a proposed instruction on unintended recording for the jury. States exhibits C, D, and E are video recordings. States exhibit C is an excerpt from the body camera of the Ocala Police Department. States exhibit D is an excerpt from the body camera video of Richard Tuck from the Ocala Police Department. And States exhibit E is an excerpt from the in-car camera of the Ocala Police Department. I've advised the defense which portions I am going to be playing today, but because it is not obviously a complete recording, I would ask for that to be played. We did not continue going forward on Detective Tuck's body camera in particular. We have the beginning of the performance. He does that for some time on this Robinson. We thought it would be unduly prejudicial to keep going.
All right. Any comment, objection?
Not from Mr. Barrow, Your Honor.
No, Your Honor.
Not from Mr. Smith.
Very good. Just let me know ahead of time, please.
And then also, I wanted to advise the defense and the court, Dontarius Hartley, who's alleged to be the victim of the last count of the information, was served with a subpoena yesterday morning. He advised our investigator who served him, Beverly Speaker, that he doesn't know nothing about this. I had a telephone call with him.
That would mean he knows everything.
He may. I spoke to him about 8 o'clock last night by phone. He advised me that he initially told the police when he was interviewed that Laquan Barrow was the one who was shooting as he was walking away from the nightclub. He identified him in the photographic lineup. When I spoke to him last night, he said that he was there by himself. He does not recall there being a fight inside, that he went outside. When he left, he was walking away. He does not recall who he saw with guns. He says everybody was shooting in the air. He doesn't know what they look like. I asked him about his identification of Mr. Barrow, and he said that he was on morphine at the time. He doesn't recall, and that he just told the police that because he saw Mr. Barrow on the news. Given that that's a material change in his testimony to the identification of the defendant, I did not have time to prepare Brady notice, so I did want to orally disclose that to the defense. And the court today, the state still doesn't intend to call Mr. Bartlett during the trial.
All right. Well, I would ask that that get reduced to writing at some point and distributed, but counsel's now on notice, so. All right. Anything else?
Also, Your Honor, we emailed the defense copies of 2 diagrams we intend to introduce into evidence. We believe they would be used by many, many witnesses throughout the trial. That would be the easiest way to do it. One is a overhead, they're both Google map screenshots of the nightclub and the area around.
When did you send that?
Last week.
Receiving.
No objection.
No objection.
I didn't have an objection at the
They'll
time.
be introduced through our first evidence.
All right. Any issues from any
That's
of the
just,
defendants?
by way of scheduling, per talking to the court, indicating that we may end early on Friday, I've advised my witnesses to be available on Monday.
Okay.
And we would be invoking the rule. I've advised them of that procedure and what they need to do with that. I do not, at this time, anticipate a full day on Monday.
Okay.
So, with scheduling, we can do whatever the court desires with that.
Hawthorne?
I would concur with Mr. Gorley, and we will have witnesses ready to go
On
on
Monday.
Monday after Mr. Gorley.
Well, it may be after is, but I want them here
Oh, yes.
right away.
that-
I don't want to try to stage it. I'd rather have them all here waiting. So,
Yes, sir. I will have them here first thing in the morning.
Mr.
We'll
Beckman.
have ours ready also, Judge.
All right, thank you. All right, and then that is a hopeful prediction that you'll be able to start Monday morning.
Yes, sir.
If things start going south and that's not going to work, then we may have to change. So I do intend, because of the late hour last night with Mr. Smith and Mr. Barrow's jury, to recess today around 4 o'clock, if not slightly before or slightly after, just to kind of let them ease into this for the next 8 to 10 days. So, at any rate, anything else before we bring the juries in?
Nothing for Mr. Barry on.
No, sir.
Nothing for Mr. Smith.
All right,
Thank you, sir.
very good. Let's bring the juries in. Eugene Smith and Gary Edward King. This is a criminal case. Laquan Ramel Barrow is charged with murder in the second degree and 5 counts of attempted murder in the second degree. The definition of those crimes will be explained to you later. Michael Eugene Smith is charged with murder in the second degree and 5 counts of attempted murder in the second degree. Again, the definition of those crimes will be explained to you later. Gary Edward King is charged with murder in the second degree and 4 counts of attempted murder in the second degree, and the definition of those crimes will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against the defendant in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, the alternate jurors will be released, and then you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. And I know I've told both groups that repeatedly. You each have your own jury rooms. You will stay together to eat lunch, things like that. But there's a common hallway where your coffee and the water and everything is located. It's perfectly fine for the 2 juries to mingle with each other. You can have idle chit-chat conversation, but nobody should be discussing the case. You can't discuss it in your own individual rooms. You can't discuss it in the hallway. I want to make sure that's clear. The only time it's going to be appropriate to talk about the case amongst yourselves will be after the alternates are discharged and I send you back to begin deliberating. That will be the first time that it would be appropriate to make any comment about the evidence or a witness or anything else. So I just want to make sure that is clear. Your verdict must be based solely on the evidence or lack of evidence and the law. As I have told you, your cell phones must be turned off while you are in the courtroom. While you may use use them during recesses, you must not use them to communicate with anyone about the case or get any information about the case. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. In other words, if a witness is answering a question and one of the attorneys stands and objects, and I sustain the objection, the witness will not finish the answer and not permitted to fill in the blank. Okay? If it doesn't come out of their mouth, you can't consider it, and you're not supposed to assume what might have been said. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. And typically what will happen is if an objection is made, or if I call the attorneys to the bench, or they ask to approach the bench, I'm going to activate an annoying hissing noise that will make it really hard for you to hear what we're saying, which is exactly what it's designed to do. If I'm not satisfied that that's sufficient for us to conduct a private conversation, I may ask both juries to leave the courtroom. We'll settle the legal issue, and then we'll bring you back in. You should not concern yourself with what we are saying when you can't hear. That's the whole point of you not hearing. Don't worry about it, okay? All right. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, you should close your pads and leave them on your chairs. You will be permitted to take your notes into the jury room only during your deliberations. So at the end of the day today, you leave your pads on those chairs. They'll be gathered up. They'll be kept secure. And then they'll be returned to you when you come back in the morning. Okay? But the only time you get to take them out of this room will be when I release you to begin deliberating. And then, of course, you'll have all the notes that you take, if you choose to take notes. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence.